Hi, my name is amish.aggarwala. Let's talk about the criminal justice system in India and one particular aspect of it, which is that no matter how many laws we discuss, no matter what are the rules of jurisprudence which are narrated time and again and are spread out to all the courts of the land by the Honorable Supreme Court, by all the various high courts of the country, the one fact which remains true, which the sooner we come to terms with it, the sooner we accept it, the better it is for all of us, lawyers as well as litigants in every aspect. The criminal justice system will always be at the mercy of the whims and fancy of the particular judge who is dealing with the case in front of him. It does not matter what a judgment by the Supreme Court in the year 1979 or even the latest ones, doesn't matter what these judgments of the Supreme Court say. There will always be another judgment of the Supreme Court or some other high court which will support the exact opposite thing of what you might be claiming in a court of law and for which you might have 5 to 10 judgments. I have a very good example with me when I remember this particular instance around 3 or 4 years ago, where a particular judge of the Delhi High Court heard 2 cases arising out of the NDPS Act, Narcotic Drugs and Psychotropic Substances Act. In both the arguments were addressed by me, the judgments were reserved. The judgment came after 3 years of the arguments being heard, and both the judgments came one after the other, one day and then the next one the next day. In the first judgment, the Honorable Judge upheld the conviction of the accused persons, saying that the presence of independent witnesses is not compulsory to establish a prosecution case. The very next day, in another similar narcotic drugs, psychotropic substances matter, that same very judge listed one of the main reasons for acquittal of the appellants, that is the accused persons, said that the lack of any independent witnesses casts a severe doubt on the case of the prosecution. As ironic as it may sound, the fact of the matter is there are several judgments both for that one aspect and against that one aspect. And it brings me back to my point. The judges will always go for what they feel is right, because at least when it comes to the liberty of a person, they'll always want to go for what their heart deems to be true, what their heart, in their heart, even if the person has committed an offense and they believe in the person or maybe in the possibility of his reform, they'll still go for, they'll still try their best to let the person go. Forget about actual convictions and acquittals. The biggest challenge that is faced by a criminal lawyer in India is securing bail for a client, and that is where there is no iota of doubt that the complete discretion rests with judicial officers. However, one trend that I have seen is that grant of bail by subordinate judiciary is looked at more with suspicion, especially in highly contentious matters or matters which attract media attention, and therefore they more often than not try to stay on the safer side and not have any fingers pointed at them, and they would rather reject bail applications than allow them. However, the appellate courts, at the very least the high courts and the Honorable Supreme Court, are much more lax, and they understand the better nuances of their cases in front of them, and that's why they are a little more agreeable to granting bail to an accused person than the subordinate courts. But one thing that you can do as a lawyer or as a litigant is to try and remember your case. When it's a criminal case, it is not so much about what the law says regarding your technical situation, the technical law says regarding your situation. What matters more is remembering, appealing to the heart of the judge matters much more than anything.